Okay, good morning, everyone. Everybody looks bright-eyed and bushy-tailed and ready to go. It's a great day out there to try to help make Wyoming a little bit better place. We've got some really good bills that we can discuss this morning, committee. Just a reminder, we are streaming live, so let's watch the offline conversations. They can be picked up somewhere. We will welcome remote testimony this morning. I think we have a little bit of that online out there, and so welcome. The first bill, well, let's take roll first. Sorry, Judy.
Senator Case?
Present.
Senator Cooper?
Here.
Senator Furphy?
Here.
Senator Schuler?
Here.
Chairman Landon?
Here. Committee, the first bill for our consideration is Senate File 24, Financial Exploitation of Vulnerable Adults. This is actually a friend of the Senate, the good senator from Fremont County, I believe brought this bill about a year and a half ago. It didn't quite make it through last year. So it went to the Judiciary Committee as an interim topic and comes out as an interim Judiciary Committee bill. Senator Case, I was wondering if you'd be willing to walk us through this bill since it was yours.
Thank you very much, Mr. Chairman. Mr. Chairman, I worked a lot with Mr. Meyer from the bankers group on this, and Corin Smith of Department of Family Services. But it starts out with a lot of definitions. On page 2, we define agent, department, financial exploitation. And financial exploitation has 2 main elements, being the wrongful or unauthorized taking, withholding, appropriating, or use of the money, assets, or other property of the identifying information of, or the identifying information of a person, or an act or omission by a person, including through the use of a power of attorney on behalf of, or as the conservator or guardian of another person. And then subgroups under that would be to obtain control through deception and to convert money and assets. We define a financial institution, which includes our good friends at the credit unions, investment advisor, qualified person, and a vulnerable adult, which is defined as it is in the Department of Family Services statute. Mr. Chairman, on page 4, we have 131702. This is the reporting of financial exploitation of vulnerable adults. So basically what this is it says if you are one of these qualified people, meaning you probably work for a bank or one of these institutions, you and you have cause to believe that financial exploitation of a vulnerable adult has occurred, you have a duty to notify. And you first notify you notify your employer, and then the financial institution has a duty beginning on B. Once it's notified, and if we look down, it says if a financial institution is notified of suspected financial exploitation, easy for you to say, under subsection A of this section, or otherwise has cause to believe that financial exploitation of a vulnerable adult has occurred, is occurring, or has been attempted, the financial institution shall assess the suspected financial exploitation, and if warranted, submit a report to the Department of Family Services containing the same information under this particular statute. The financial institution shall submit the report required not later than the early of, I'm on page 5, little Romanet I, the date that they've completed its assessment, or 5, Romanet 2, 5 business days after the date that they're notified. So they got to be pretty quick about turning this around. Part C, lines 15 through 21. If they do this, they don't have to make further reporting. And we're on page 6, it's part D, it says that the financial institutions must make some internal policies to implement this. And we're down to 131703, bottom of the page. This is the ability to notify third parties. So if a financial institution submits a report of suspected financial exploitation of a vulnerable adult to the department under this section, the financial institution may, at the same time, notify a third party reasonably associated with the vulnerable adult. And you can think about this and just think about this scenario now. I'd like to just stop for a second and think what we're talking about. I bet Senator Furphy is, in his career in banking, has probably come across situations where something's just not right. We have neighborhood banks in Wyoming, neighborhood credit unions. People, do business with them for a long period of time, and then something goes awry. Maybe they no longer able to come to the bank themselves and somebody else is coming, but maybe the transactions don't seem to line up with what you would think in terms of protecting and providing for these folks. And it's, in that situation, there might be a third-party notification that might be required. Just imagine, you can make up a million scenarios, but a teller knows that this part-time employee of this person has come in and tried to withdraw a lot of money. And the bank might decide after this notification that, why don't we call the person's oldest child who lives in Texas and just ask him if this sounds kosher. That's kind of where we're going. Might be able to head off some things. So page 7, 131704, this allows a temporary hold to be placed on transactions. I'm not sure where this ended up, actually. We went through different time periods, and some folks wanted longer and some folks wanted shorter. But that was a lot of discussion. But the point is that we can put a hold on the transaction to avoid losing the money, basically. And I think the rule is, we look on page 8, it shall not exceed 5 business days after the date the hold is placed. But then in C on line 14, it says a financial institution may extend a hold for up to 30 days if requested by a state or federal agency or law enforcement. Again, we got internal policies required on page 9. 131705 is immunity for our friends at the banks. If they're acting in good faith, they question something, they bring it to the attention, they talk to DFS, they do everything according to this law, they have the policies in place, then they're not going to get in trouble or suffer liability for complying with the law, Mr. Chairman. And it's possible you could make a mistake. There might be a reason that the gardener ended up getting a new pickup from Mrs. Jones. There might legitimately be that reason. But what's the damage done? If there is a hold, maybe we don't get the pickup for 5 days or possibly 30 days. That's not the end of the world. If Mrs. Jones loses her entire fortune that she was ready to live the rest of her life on, that's severe damage. 131706 is about records, and I'm clear over to page 11, section 2. The Department of Family Services will provide rulemaking, and it's effective on July 1st, 2023, although other sections are effective immediately so that the rulemaking can begin. With that, I'd be happy to answer any questions. Certainly, Mr. Meyer here, he spent a lot of time on this bill. Director Schmidt is here. She has been in the trenches with us and done a great job.
Senator Case, thank you very much for walking us through the bill. Committee, any questions of the senator thus far? I want to I was going to welcome Senator Nethercott. I think she stepped back out for a minute, but we'll get to her a little bit later here. I'm going to ask if Director Schmidt would like to come forward from the Department of Family Services. Good morning, Director. Thank you for being here early on a Friday morning.
Yes, good morning, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Wyoming Department of Family Services. And we've appreciated the opportunity to work with the Senator, with the Banking Association, I think also with the credit unions as well, in AARP have all been really good partners in this bill. This is an issue that we encounter frequently in our adult protective services cases. It's a little bit different when it comes to adult protective services because the agency doesn't quite have the authority it does when it comes to children who have been abused and neglected. So much of the work we do in regard to adult protective services is case management, resource finding, trying to connect vulnerable adults with whatever they may need so they can, one, hopefully stay safe at home, or two, if they do need some sort of placement, work with those agencies and those entities that can do that. We do see financial exploitation in it. It's a tough area to be. There's a lot of emotion that can be wrapped up into it. Oftentimes it's family members who's doing the exploiting, unfortunately. And so it can get a little tricky for us. Having the banks being able to kind of flag a little bit and get involved a little bit quicker because they may see it before anybody reports it to us, just gives everyone time to really understand what's going on and then make some decisions if it is exploitation or not. We understand that there are times when adults get to make decisions, certainly about their finances, and we respect that. But we also know that there are times when maybe because of age or whatever reason that maybe they're also going to be taken advantage of. So we don't like to get involved if we don't have to, but sometimes when we do get involved, it's too late and resources are depleted. And by that time, there's really not much we can do. We partner with law enforcement in these cases. And so having the communication with them and kind of that loop between the financial institution, law enforcement, and with us is very helpful in being able to address any of these problems immediately or identify immediately that there are no problems, and then we can back out.
Go ahead, Senator King.
Well, I just wanted to say that the department's been fabulous to work with, and believe it or not, the first time we put vulnerable adult in the statute, that was my bill, and that was a long time ago. And they were worried, everybody was worried that there was going to be this huge meltdown because suddenly the workload would go up so much. And really, I don't think that's been the case, and we've done some good things, and I appreciate the department throughout all that.
Thank you, Senator.
You know, Director, just as an aside, this really hit home for me, having aging parents over the last 6-7 years. We had a situation where my mother's jewelry left. She had a friend who became a very good friend, young lady who kept coming up to spend time, and we don't know. But so this doesn't cover the whole sphere, does it? You deal with a lot of things beyond this bill, but tell me a little bit about the rulemaking. Do you have any concerns at all about rulemaking to set this up and be able to, okay?
No, Mr. Chairman, we have no concerns. Certainly, we will have to update our rules, but that's pretty typical with a lot of legislation. So, no, we think this, we feel fortunate that this discussion is happening because we do think that we may be in a better place to be able to help people out.
Okay, thank you very much. Appreciate all your work on this.
Thank you, Mr. Chairman.
Senator Nethercott, good morning. It's good, always good to have you back home in the Judiciary Committee room. If you'd like to visit with us a little bit about the interim work that you did on this bill, or any other thoughts Good morning.
Sure, Mr. Chairman, thank you. Good senators, the Joint Judiciary Committee did work this bill very thoughtfully during the interim. We had the help of the Good Senator Case, the Bankers Association, and of course, our regular support for this Judiciary Committee, which is law enforcement, and a number of attorneys who work on the Joint Judiciary Committee as well. And look, I think the bill is ready for prime time, and look forward to seeing it through, as you've all identified, the important concerns associated with the harm that can be caused by financial exploitation of vulnerable adults. So certainly a very important issue, and look forward to seeing its passage.
Any questions of the former chairman?
My heart's a flutter.
Yeah. Senator Cooper.
I do that in the morning.
Senator Cooper.
Oh, I'm not a flutter, but I am impressed with the work that's been done on this bill by Senator Nethercott and Director Schmidt and Senator Case. There was a lot of thought and time put into this in the interim and last year. It's a very necessary bill, unfortunately. It shouldn't be, but it is. I'd just like to ask the good senator if she thinks there's any holes in it, anything more we can fix on it before we move it forward.
Senator, go ahead.
Mr. Chairman, no, I don't think there's any holes in it. I would just be mindful or considerate that the industry, as Senator Furphy likely knows, being a former banker, would always want more and more protections associated with these. You probably couldn't have enough when trying to navigate one of these very complex human situations concerning what is and isn't a vulnerable adult. And so I do think the bill strikes the right balance there by providing the right protections for financial institutions and those that want to protect vulnerable adults.
So, Senator, to follow up on that, it keeps fluttering into my mind. If a banking institution steps out on one of these and it ends up not being the situation that they thought it was, do you have any qualms at all about that? And are we covered in here with the immunity piece and et cetera?
Well, Mr. Chairman, with immunity, as you might recall from last year's discussion and my concerns about that, there is no greater legal protection that can be provided to any person or entity other than immunity. And so that means there's no responsibility for any conduct. We have given them that.
Thank you very much. Really, really appreciate it. Senator Furphy. Then we'll go to Senator Schuler.
Thank you, Mr. Chairman. Yeah, that immunity issue is a big issue for banks. And I'll be interested. I see the Division of Bankings here. I would like their input on that because the Bank Secrecy Act, distributing personal information is a concern. So, but this immunity you have in here, as an attorney, you think the banks are pretty well protected?
Mr. Chairman, the Banking Division, we did hear from them during the interim, and I look forward to hearing their comments today, and the Banking Association is also here. It's important to recognize that the state and we as state legislators can only provide state immunity, and so we can provide no immunity protections against federal law violations.
Follow up, Senator Furphy, you good? Yeah. Senator Schuler.
Thank you, Mr. Chairman. I actually have two questions. I probably should have asked Director Schmidt one of them. I'm kind of interested in knowing most of these cases that happen with the vulnerable adults are happening mostly with our older generation, or is it folks that maybe are over 18 that have some mental disabilities? That's my first question. And I'll wait for the second.
Okay, yeah. Senator?
Mr. Chairman, certainly vulnerable adults could be any one suffering from any kind of disability, which could be one that we generally think of when it comes to advancing age and cognitive decline, or it could be from some other type of condition that makes one vulnerable. And that certainly is an ambiguous and broad term because that is subjective. Traditionally, however, I think it's fair to say that most of these circumstances do involve what you commonly think of, which is the older adult. And the reason for that is they have assets. And so they're more likely to have significant resources in a financial institution, making them even more vulnerable to exploitation.
Things like jewelry.
Follow up?
Yeah, go ahead, Senator Schuler.
Yeah, my question, I don't necessarily have heartburn with this, but on page 8, when the banks go ahead and do another hold for 30 business days, do you think that's going to create some issues with some of the folks on the floor?
Go ahead, Senator.
Mr. Chairman, through you, I think that is a possibility, certainly. I do think, and that's subjective as well for how to provide the appropriate protections to prevent someone from being truly harmed in a way that may be irrecoverable.
So as a follow-up to that, Senator, what was the conversation like during the interim regarding that 30 days? Is that enough? The flip side of the coin is that enough to get everything done? And maybe we check with the banking association too, but is 30 days enough to protect somebody?
Mr. Chairman, that does seem to be the right balance. That figure did come, I think, from the bankers at their suggestion. The Joint Judiciary Committee, to my recollection, didn't really focus on that too much, being less kind of concerned about maybe the power of someone else than maybe some other committees or members of the legislature might. So I do think that that's probably an appropriate time period based on stopping a transaction and reversing a transaction and getting money recovered back, that's an appropriate amount of time.
Thank you, Senator. Anything else for Senator Nethercott? Senator Case.
Mr. Chairman, she's super smart on this. I think a couple of things that could play out. Is 30 days not enough? It's possible it would be in the courts by that time. You'd have some protection for the assets by that time. And remember that 30 days is in response to a request from authorities. And if I could just barely tag on, I think this is more poignant now as we are an aging population. We have a lot of people living alone, and their circumstances change over time, and they just to get by, you have to rely on other people. And you have to. You rely more on the neighbor to do chores for you. You try to find some kid to help out, and family's struggling, and so you reach out more, and there's less family connections. So that's probably a sign of our time in the future. That's what makes this kind of timely, I think.
Senator, those are very good points and things I thought about last night reading this bill. That you're right. You require neighbors to come over when you begin to fall. Sometimes in the middle of the night, you need some help. Lots of other people come into your life and surround you, and most of them are very, very helpful. Senator Furphy.
Thank you, Mr. Chairman. Just a comment. When I was in banking, this happens a lot. It was a big issue to the extent our compliance officer, we had training for all of our employees to monitor this issue because, as Senator Case pointed out, our population is aging and they're becoming more vulnerable to people trying to help them, but also abusing them. So I just wanted to make that comment. It is a big issue.
Thank you, Senator. Senator Nethercott, thank you again for being here. We look forward to working with you through the morning here on a couple of other bills, and we reserve the right to maybe ask a question later on this one. So thank you. Appreciate it. I'd like to go to the Banking Association before we go to other testimony on the bill. Mr. Meyer, good morning. Nice to see you. Thank you for all your work on this. Good to see you.
Thank you, Mr. Chairman. Scott Meyer with the Wyoming Bankers Association. I want to just start by telling you that, Senator Case and I worked on this probably because a little over a year ago, I received a call from a bank in Fremont County that said, Mr. Meyer, we'd like to see you. Please come in and see us. And I thought, well, the next time I'm in town, I will. And before I could say anything like that, the bank officer said, how about tomorrow morning at 9?
Yeah.
Well, I'm in Cheyenne. And then before I could say anything else, they said, and bring your mother. So that started this, because as we looked at this, I watched somebody try to take advantage of my mother. The end result was the bank knew my mother, knew me. We got it all stopped. We figured out ways around it so that we could do it without breaking any laws and have any rule issues. But it certainly was one of those things that highlighted for me the importance of this. Through and with the help of Senator Case, we did draft a bill, and I will make a comment that I think, much to my chagrin, Senator Nethercott and the Judiciary Committee forced us to make what I thought was a good bill, a better bill. So I thought last year it was ready for prime time. I think that Senator Nethercott's comments are right. I think it is much better now, and I really am proud of the work that everybody did.
Mr. Meyer, I think every one of us have suffered that same fate.
Yes.
Thinking our bills are ready and they're not quite ready.
Right, exactly. When I go through the bill, and I think Senator Case did a great job going through it, but there's just seems to be always some lingering questions as we go through this that I hear from other folks, other legislators, but just even parties out there that, well, why can't you do this thing through like the bank, some of the other legislation that's out there? So right now, the banks don't have any protection. And when I say banks, I mean any financial institution. As you can see in the bill, we modified that from last year, so now it includes broker-dealers. And it includes investment advisors. Those folks deal with the same issue. If a financial institution does not pay a check because they think that that's a problem out there, they're liable for wrongful dishonor. And under the UCC, a bank can only hold a deposit for a short period of time. And if they hold it for longer, they can be liable as well. So that's why it is really important that we make sure that financial institutions do have the wherewithal and the guidance to make sure that we put whatever holes that we can on there to help protect our customers.
So, Mr. Meyer, real quickly,
Yes.
sorry to interrupt, but what you're referring to is what Senator Furphy also referred to, and that's banking regulation at the federal level. Is that when you talk about a bank being held liable?
Mr. Chairman, there's a couple of those. Yes, as Senator Furphy referred to as the Bank Secrecy Act, we have some requirements there that we can't share that information. We also have other laws out there under what they call the KYC, or Know Your Customer. That's why I think these financial institutions probably are the best ones at the point to see what's happening right on the front lines. And then there is the Senior Safe Act, which was a federal law, but that only deals with people over 65, and it does not provide near the protections, nor does it provide for near the information that we can share. The primary purpose not only is to stop this transaction from going on, but then it allows the agency or law enforcement to move forward very quickly because they don't have to seek a subpoena for records. This bill allows those records to be produced. And that's where I think it's to be critical as to what the bank can and can't do. And now with this kind of a bill, the banks can say, we're allowed to give this information to law enforcement. We don't have to go out and seek court approval or what have you, so law enforcement can do that. The other thing I would bring to your attention is, as I read through it, I think that the bill is pretty well written. There are a couple of changes that I would like to propose. And these came through as we discussed them in the interim committee. But one of those, and I would certainly hope that we can get further comments from Director Schmidt as well, because I think these play into where she's at with her agency. But the first one that I want to talk about is online, page 6, beginning for 13-1-703. So when you read that, starting with line 22, it says, if a financial institution submits a report of suspected financial exploitation of a vulnerable adult to the department under this article, comma, the financial institution may, at the time, the financial institution submits the report, notify a third party. Our thought is this, is that if in fact there is a situation that perhaps the financial institution can reach out and find out ahead of time that this may be a very quick way to deal with a problem, find out if there is a problem. And using the kind of the example that Senator Case used, we may have a person that is relying on their son to take care of them, to do things daily, but they may have designated a third person being that daughter that's in Texas. If the son is doing stuff, or if the gardener needs the new truck, whatever, and that is a legitimate concern, assuming, of course, and this is where it gets kind of dicey a little bit, but assuming that the daughter in Texas is not in cahoots, then it would seem to me that if they could reach out to the daughter and say, there's somebody trying to buy a pickup for the gardener, for the son that's in construction or what have you, this does not seem right. And if the daughter or whoever that third person is can say, no, that's true because mom really wanted the gardener to have this, that isn't her intent, or mom really wanted to help son out because he's been taking care of her and he has a business that needs to pick up. If that can be resolved quickly, then it would be without filing the report. That may move things a little bit quicker than just verifying it. So with that being said, then I would suggest deleting lines starting on page 6, 22 and 23, going over to 27, the first part of line 1, department under this section, then leaving the financial institution may, and then deleting at the time the financial institution submits the report. Notify, just so that it's not necessarily required to file a report to notify that person. Now, I will defer to Director Schmidt as we've had that conversation. She points out, and I will not testify for her, I will let her speak, but sometimes they are in cahoots. And sometimes there are problems where by notifying somebody ahead of time, we have inhibited their ability to do an investigation. So it's one of those things where I'm not sure. Yeah, I think it would make sense for the financial institution to be able to reach out to that third party. But I think at that point in time, that's going to be a judgment call. The other change that I would have in there is on the temporary hold transactions under 13-1704. And we had this discussion in the interim. Beginning on page 8, line 9, there's a paragraph talks about how long they can hold those funds. And the discussion, originally it was written for 10 days. It's now been changed to 5. Your bankers would like to see that change back to 10 only because we see the difficulty sometimes getting things through the process. And that may be resolved through rulemaking, through whatever the Department of Family Services does, what have you. We just want to make sure that hold doesn't expire before law enforcement or the department gets dealing with it. Those are the changes. I will say that finally is that the question keeps being proposed to me as to what's the worst case scenario. And I think that Senator Case made a comment about it. You may have a lost opportunity. If that lost opportunity is for 5 days or 10 days or what have you, it could be significant, but most likely it's not. And there's also, the idea of what happens if, we were wrong and we held that. And there will be times when that happens. And banks will have egg on their face. We stopped this, we probably shouldn't have. But it's better, I think it seems like that's a better alternative to say, we slowed this down for 5 days, as opposed to we didn't and that money's gone. So I think that those are the areas that we're in, but we are definitely in support of the bill. We appreciate everybody that's been working on it. And I think that, as everybody has mentioned, we don't have time for all these kumbaya things, but Tom Laycock has worked very hard on this as well, so. Stand for any questions, sir.
Mr. Meyer, thank you. Appreciate all your work on this, and we'll take up those considerations that you've provided to us this morning. Senators, anything for the Banking Association? Mr. Meyer? Thank you, Mr. Meyer. We reserve the right to get back to you and ask another question later.
Thank you,
so
and I think
you.
that's the first time I've not had any questions, so.
Appreciate it. I'm not going to go all the way down the list, but I'd like to hear from Mr. Laycock next, and then we'll go to testimony on the bill.
And I believe the Division of Banking is here as well.
Oh, thank you. I appreciate that. I'm still getting up to speed on all fronts, so we'll go to the banking division here in a minute. Mr. Laycock, I called on you because you and I have had a conversation or two on this front, and I know you've been involved too, so thank you for being here.
Thank you, Mr. Chairman. Good morning, committee. I'm Tom Laycock, Associate State Director for AARP Wyoming. We're speaking in support of Senate File 24. I want to thank you for continuing your work to create protections around financial exploitation and abuse. As legislators, you're in a pretty favorable position today. So this bill was actually written in part off of model legislation that's in 34 states. So you've got a bill in front of you that's actually ran the traps in 34 other states. They've seen the real world situations they've kind of dealt with thus far. The good news is none of the 34 states that this has been imposed in thus far have needed significant changes or repealed the bill. So that's kind of a good road test. There was question about the Senior Safe Act a little bit ago. In other words, does federal legislation already allow for a stop on a transaction that's feared fraudulent? And I'll tell you, actually, the Senior Safe Act was passed by Congress in 2019 and really is more of a carrot to financial institutions. So if you provide training to staff on how to identify and report incidences of financial exploitation specifically to those 65 and over, you do receive protection for being sued for reporting the concern to a state agency and law enforcement, but not necessarily for making the stop. And that's where the NASAA and these other states have taken that model legislation and paired it with the Senior Safe Act. So like I said, thus far, 34 states have it, including Texas, Alabama, Utah, Oklahoma, North Dakota, Nebraska. So we've had a number of questions about that, a number of comments about that. If you have other questions really about this bill, Brian Fuller from LSO put together a dynamite memo on the situation this summer. So did a great job. For our fraud prevention work, we like to say, stop, think, and verify if you think that you're a victim of a scam. And this really allows banks and credit unions the opportunity to do the same thing. So that's why we're in favor. So simply put, our hope is that this bill provides one more arrow in the quiver in our fight to protect those who cannot protect themselves from financial exploitation. So that said, I'll be happy to sit for questions.
Tom, thank you. Any questions for Mr. Laycock? Thank you, Tom. Appreciate it. Oh, Senator Case.
I'd just like to thank Mr. Laycock and the AARP for all their help on this bill. Thank you very much.
Thank you. Let's go to the banking division, and then we'll get on to further testimony.
Yes, good morning. My name is Jeremiah Bishop. I am the State Banking Commissioner, and I oversee the Division of Banking. And part of why we're here is we administer Title 13, which this is a part of. However, this gives a lot of responsibility to the Family Services, which I think makes sense. However, part of our responsibilities in the Division of Banking is to ensure that our institutions are in compliance with state and federal laws, including Title 13. And so our job would be to ensure that if this bill passes, that our banks and trust companies, those are the only institutions we regulate. We do not regulate the credit unions, but that our institutions are following this bill. And we would mainly focus on the policy section. So on page 6, when it discusses what type of policies and procedures must be in place for the qualified persons in reporting, and then also again on page 9, and that is a policy on actually placing a hold on the transaction. So that's kind of what our role would be, is to ensure that those policies are in place. And I think that would also help a little bit with the immunity case. I think that's a big thing in banking, that if you have strong policies and procedures in place and you follow them, if something is ever questioned, you can point back to your policies and procedures and say that you did follow them. That helps in quite a few cases. One question that did come up was the immunity function and how that relates to other immunity. I think Mr. Meyer did a good job of discussing some of those. One I did want to bring up was that for the Bank Secrecy Act, BSA, and suspicious activity reporting. So banks are currently required, if they suspect suspicious activity, they are required to fill forms out and report it to FinCEN, which goes to other federal agencies. So this is something that banks are already trained on identifying and reporting. The time period for that report is a little bit longer, but they have to have policies in place for that. And I believe there's also a federal a law in that suspicious activity report in BSA that provides for immunity to banks if they make that suspicious activity report. So there's another similar immunity clause for that reporting, but again, not the whole. So that's all the comments I had. Like I said, our role in this is going to be somewhat limited to just ensuring compliance, but wanted to see if anyone had any questions.
So Senator Schuler.
Thank you, Mr. Chairman. I just was interested in knowing your thoughts on page 8. When, what do you think about changing the 5-day hold to 10-day? Do you have any thoughts on that?
Yes, thank you, Mr. Chairman, Senator Schuler. I don't know if I have any thoughts on that. I think if the bankers say that that's a good idea, I'll leave that up to the bankers and Mr. Meyer. The only way I could say this is whether it's 5 days or 10 days. What do they have the appropriate policy for that to make sure that they can make that report within that time period? Some banks, it'll be a little bit easier because it's smaller banks. Other banks, if it's in multiple locations, that might have to report it up the chain quite a bit. So I think that's a good question for the bankers, which I think Mr. Meyer did a good job of discussing.
Any other questions? Mr. Bishop, are you comfortable with the enactment date, the ability to get the rules in place? Any concerns?
Yes, thank you, Mr. Chairman. I'm not sure if I'm the best one to answer that, since it actually directs Family Services to make the rules. Our role is, we won't be helping with those rules. So I think if Family Services is okay with that date, that'd be up to them.
Okay, thank you, Mr. Bishop. Appreciate you being here.
Thank you.
Thank you very much. Okay, let's go to further testimony on Senate File 24, financial exploitation of vulnerable adults. Morning, Mr. Winnie.
Mr. Chairman, Bill Winnie, Sublette County. One of your questions had to do with, can you recognize when an adult is losing their mental capability or whatever? And I have two cases I'm going to describe that I think show you that can be medically very clear. In the case of my father, who passed away in 1995, I was on active duty in the Western Pacific. He died from emphysema. The doctor that treated him spoke with myself and my wife along the way, and it turns out in the case of emphysema, there is about a 10-year slide in cognitive or dementia capability of a person. He had you spoke of a gardener earlier, somebody helping around the house. It turned out that guy was writing himself checks out of my father's account. And they were even amount checks, $100 here, $200 there, which I think would be a detectable pattern. The second case was my father-in-law, who was a 100% disabled veteran from Japanese prisoner war camps. And about 2002, the law was changed with regard to disability pay that enabled him to receive concurrent receipt of disability pay and retired pay. And he had then had an increase in his income of about $1,500 a month that almost nobody in the family recognized. It just started showing up. And one of the members of the family started writing checks again out of the account, and it was just not visible. And in his case, he passed away from something with his pancreas. They never would quite call it cancer, but they gave him a 13-month time to live. And in fact, he is equally had about a 13-month slide in mental capability. And so this money just kind of wafted out of the accounts, and nobody ever quite realized it. And so I would posit for you all, as you consider this bill, that banks can tell sometimes these kinds of patterns. And when they see a pattern, a recognizable pattern for a person like this, they report it to the Adult Protective Services or whomever, who then would be the persons that would do an investigation. Perhaps there might be a legitimate explanation, as you've discussed, but the pattern in these cases went on for about 2 years, probably 3 years in the case of my father, as he was in the last stages of the emphysema, and for about a year in the case of my father-in-law. And as we went back and looked at it, it was clear. And we're talking things like $10,000, $20,000. So subject to your questions, thank you very much.
Mr. Winnie, that's helpful. Thank you very much. Any questions? Thanks for being here. Appreciate it. Further testimony on Senate File 24. Good morning.
Good morning, Mr. Chairman, members of the committee, Bobby Frank, and I'm here today on behalf of the credit unions of Wyoming. Full support of the bill. We're a little late to the game. I started with credit unions in September, so we're very appreciative of all the work everybody's put into this bill. The only comment that we have or consideration in discussing the bill with the credit unions is if on page 5, line 8, the issue was raised, it would be nice to have an extra few days to be able to conduct due diligence to ensure that we're filing substantiated reports with the department. You have to excuse my voice. I've suffered from some vocal cord damage recently, so.
No problem, Ms. Frank. Thank you. So on page 5, when we refer to 5 business days after the date the financial institution is notified, you're saying that a few more business days would be helpful.
Correct, Mr. Chairman. What was requested is if you would consider changing that from 5 to 10. And what was described to me is, like previous testimony, is sometimes there's an activity that occurs that appears to be off, but they need to keep an eye on that. And then there may be subsequent activity that confirms, yeah, we have a fraud situation here.
Pardon me. Mr. Chairman, I have a bill up next door. It's the Lester Hunt resolution. I certainly support the bill and would be happy to leave a proxy alive. That's all right.
You're welcome to do that, Senator, absolutely, and good luck on the other bill. We'll see you in a little bit. Sorry for the interruption, Ms. Franks. Senator Case is due across the hall to present another bill, so pardon the interruption.
Mr. Chairman, no problem.
Okay. Please continue. Anything else on the bill?
Mr. Chairman, no, other than full support for the bill.
Okay, thank you, Ms. Frank. Any questions? Appreciate the credit
Thank
union
you.
being here. Thank you very much. Please come forward. Absolutely. Testimony on Senate File 24, Financial Exploitation of Vulnerable Adults. Hopefully we have green lights on with both of the microphones.
Yes.
Good
Good morning.
Welcome.
My name is Rhea Parsons. Mr. Chairman, good morning. My name is Rhea Parsons. I'm a Realtor here in Cheyenne, Wyoming, and I'm sitting here today as a support person for Mrs. Hoyt, sitting next to me.
Good morning, Mrs. Hoyt.
Good morning, Mr. Chairman and members of the committee. My name is Mary Ellen Hoyt. I am an 86-year-old. My husband is a 93-year-old Navy veteran who served on the Coral Sea during the Korean War. In June of 2022, in preparation for knee replacement surgery, I had a power of attorney drafted as a precaution in case of any severe complications, which may have incapacitated me. In the power of attorney, my elder daughter was named as the primary agent. Unknown to me, my elder daughter used the power of attorney, her power of attorney, to remove substantial sums of money from my and my husband's bank accounts. Had Senate File 29 been in place, it would have allowed the bank to freeze my accounts, our accounts, and find out that we had not authorized the tens of thousands of dollars in withdrawals. It would have also clearly defined what she was doing as a crime, which may have deterred her in the first place. In the absence of deterring her, it would have given clear direction to the police that this is a prosecutable crime. She used the power of attorney to set up a bank account that we did not know about at a bank that we did not use to receive the proceeds from the impending sale of our house here in Cheyenne. If not for my other 3 children locating a filing at the Laramie County Clerk's office and discovering her activities, she would have been able to take all of the proceeds from the sale of our house. Monies that my husband and I need to survive and remain reasonably independent, not being a burden to the taxpayers of Wyoming. And this is very important to us. We certainly would not have had the financial resources to pursue a civil case for the return of our property. We would have been at a dead end. When we went to the Cheyenne Police Department for assistance, we were told that it is a civil matter because there was a power of attorney in place. We felt helpless, feeling that the reviewing officer did not take into account the time frame and activation clause in the power of attorney document. We reported the first few actions by her, which predated her power of attorney. The Cheyenne Police Department is now investigating the matter. We are fortunate in the support system that we have to help us negotiate the legal process. But what about those who do not? We are very concerned about those who are not lucky enough to have the support system that we have. Neither my husband nor I have ever been in trouble with the laws, so this is completely foreign to us. Imagine how it feels when you are told that something which should so obviously be a crime is a civil matter. You're going to have to spend many thousands of dollars to hopefully recover your property and money. Imagine being the law enforcement officer who has to tell those people that the loss of their life savings and property is not a crime to the state of Wyoming. You need to give law enforcement officers the tools to help protect the vulnerable populations of Wyoming, something they are sworn to do. This has impacted me in many ways, including in losing an untold amount of sleep with so much stress that my hair has started falling out. It also has tremendously impacted both my husband's and my self-confidence. We have to worry about the impacts of stress is having, and I worry so about my 93-year-old husband. My husband and I stand in support of this bill so that others do not have to go through what we went through. Thank you for your consideration. You know, I am so sorry, but I had my pages numbered.
Well done.
And did I do this one?
You did.
All right.
You did it all.
You did,
I'm so sorry.
She
This-
did it.
you did
This-
awesome. Mrs. Hoyt, thank you. You're the very reason for this bill.
And
And
it is
please take a little bit of comfort in knowing that you've provided some great help to us today to make sure this doesn't happen in the future to somebody else. We're going to do everything we can, okay?
Yes, that's wonderful. And then we don't have to worry about the people who have no support system. And there are those out there who just, and to negotiate through what we've been through only because I had a son who came down from Sundance to negotiate me, and he's a police officer and deputy sheriff. He negotiated me through this, and it's a lot of walking and a lot of, well, thank you for.
It's a lot. And you're absolutely right. There are a lot of our folks out across Wyoming who don't have the support of people like Ms. Parsons and the senator right next to you. You're very fortunate to have them. Thank you, Mrs. Hoyt, for being here. It means a lot to us, so thank you very much. Ms. Parsons, thank you for your efforts in coming alongside Mrs. Hoyt.
Mr. Chairman, thank you.
Okay.
Absolutely.
All right, thank you so much.
Thank you for your time and your work and efforts.
Appreciate it very much. Okay. Senator, do you have as we wait for somebody else to testify, you please stay put. Any other testimony on Senate File 24? We're working our way through Senate File 24. Any other testimony? Judy, do we have anyone online
No, Mr.
waiting to
Chairman,
testify on 24?
Mr. Chairman,
Senator Cooper?
a couple of questions for Senator Nethercott, if we could.
Absolutely.
Senator Nethercott, Mr. Chairman, thank you. Senator Nethercott, do you recall in interim the discussions we had about 5 days rather than 10 days? And could you elaborate on that just a little bit?
Mr. Chairman,
Senator?
I do, Mr. Chairman. That has been a consistent position of the bankers to request more time. It was the committee's deliberative decision to take it back to 5. My recollection of some of the rationale for that is if you suspect that criminal activity is occurring and a vulnerable adult is being exploited, it's necessary to make it a priority.
Go ahead, Senator.
Thank you, Mr. Chairman. Based on the testimony of Ms. Hoy here, do you see any reason that this bill should not, in its entirety, go into effect immediately?
Mr. Chairman, I know that's compelling when we hear some of these stories. It's important to recognize that some of these activities that you're hearing about are actually crimes and are investigated by law enforcement and with the cooperation of both Department of Family Services and the financial institutions. This just helps strengthen the laws and really protects banks, encouraging them to be more cooperative and being proactive in recognizing these types of behaviors and then having immunity for them. But it is illegal to take money that doesn't belong to you through the exploitation of a vulnerable adult. I just want to make sure that's clear for the committee and for the public. It is a crime, and so I do not do it, or you could be punished. This provides protections to the financial institutions for greater cooperation in the reporting of these types of crimes and the ability to utilize those funds by powers of attorneys or others who may making these adults more vulnerable. So I do think the enactment date of July 1st, as we normally have bills, is appropriate, particularly in light of the rulemaking requirements with the Department of Family Services and enough time for the banks and the credit unions to get their rules and policies updated.
So Senator, really what we're doing is enhancing our ability to fight this kind of crime. This gives us another light to shine on things, and thank you for reminding us that it is against the law. Sometimes, as Mrs. Hoyt pointed out, it can be very, very difficult to have to walk through that process, and appreciate that. Any other questions of Senator Nethercott? Really appreciate you being alongside on this bill. I am going to close public testimony on this bill. Committee, what's your pleasure?
Yes, Bill.
Moved by Senator Cooper. Discussion. We have a couple of considerations that were provided to us. I think we covered the working days. Unless the committee feels otherwise, I feel pretty comfortable with the 5 days. If we find out down the road that that's just not working, we can maybe revisit. And I'm looking at our credit unions and our bankers. We had another suggestion over on page 7. Pages 6 and 7, if a financial institution submits a report, I think I'm comfortable with that report, at least making sure the Department of Family Services is aware, rather than just going off across the world and notifying folks. But Senator Nethercott, do you have any thoughts on that front? Was that touched on during the interim?
Mr. Chairman, it was a concern brought to us by the bankers as well, and the committee, again, through the deliberative process, chose to still have that as a requirement for a report being made to an official government agency associated with concerns over exploitation of vulnerable adults. I think the policy decision behind that is prudent, and certainly there's a record being made in a confidential way associated with that. I'm sure the bank or the bank teller who has the authority maybe to make some calls, and they feel comfortable with that quick call, may just be the tip of the iceberg, and a report to the department, and at least having that recorded is probably a prudent decision to keep in the bill.
Senator, it's almost, contact Department of Family Services, just so you know. We've got a situation here that we're going to follow up on. We're going to call somebody from Mississippi and check in on this, but at least it's documented. Yeah. Okay, committee, are you ready for question on the bill? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. I just wanted to make sure that Director Schmidt is okay with the bill in its entirety. She's saying yes, okay. I'm good with that.
Are we getting a head nod?
Yep.
She's hiding from me.
I think there's a
Are
purpose
we
for
good,
her hiding.
Director? Thank you again for all your work on this bill. Question on the bill? Judy, please take roll on Senate File 24.
Senator Case,
He left an aye vote.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Linder.
Aye.
Mr. Chairman, we have 4 ayes, and are we keeping it open then for Senator Case?
He left an aye vote.
You left an aye vote, okay. So that makes 5 ayes on Senate File 20.
Okay, Senate File 24 has passed the committee and will go upstairs. Senator Case, I know, will be willing to carry that, and we'll all back him up. The next bill for our consideration is Senate File 108, Court Reporter Fees, District Court Discretion, sponsored by Senator Nethercott, and Senator Nethercott is here. So welcome again. Thank you, Senator. Walk us through Senate File 108, please.
Good morning, Mr. Chairman, members of the committee. What you have is court reporter fees, district court discretion. And so what this bill does is it repeals the statutory requirement for the legislator establishing transcript fees, page fees, on behalf of the court reporters of the state of Wyoming. And instead of us, the legislature, doing that, really put it in the more appropriate place, which is in the district court rules, which really governs the majority of their conduct and requirements and standards. They are an employee of the district court, and the district court sets out, pursuant to the district court rules. And I brought along with me, just for demonstration, that we make most of the green books, we lawmakers, legislators do, but then there's another green book that we don't really use or see often, and that's the Wyoming court rules. And these are made by our courts across the state. And so the Uniform Rule of District Court under Section 900, and I have a copy here if you'd like, outlines all of the requirements for our district court reporters in the state of Wyoming, keeping in mind that this bill has nothing to do with setting their salaries or doing anything like that. It really has to, it just has to do with page fees. And court reporters are allowed to charge for their services and for the documents that they produce, a transcript, and they are able to charge by page. Typically, and most commonly, lawyers both arrange for a court reporter to be present, depending on the type of case that's being heard. And then they also may order a transcript, and then they pay for that transcript as well. So these fees are being directly paid for typically by attorneys, not necessarily always the case. Certainly an individual appearing in court can pay for that transcript. And of course, the argument can be made that the attorney passes those fees on to their clients. Yes, yes, of course, that's true. But the attorneys really are the ones responsible for making those payments and ordering those transcripts from the court reporter. And so it really is kind of a level of micromanagement of the legislative body that doesn't really interface with the court reporters very often, putting that in the more appropriate body that does, requiring the rulemaking through our district court process, which does provide that public notification, most notably to the attorneys who are feeling the weight of those changes of a transcript fee being increased or decreased as circumstances may require. That's the bill, Mr. Chairman. I'm happy to stand for questions. I also have with me the Honorable Judge Sharp from our local district court, as well as the court reporter, one of the best in the state, Tammy Fleming here, who is really just the consummate professional when it comes to court reporting and the rules and standards associated with that profession.
I've got an idea. Maybe the judge and Tammy would like to come forward and sit up here with Senator Nethercott. Thank you, Senator, for running us through the bill. While they're making their way up, committee, any questions of Senator Nethercott? Senator Furphy.
Thank you, Mr. Chairman. And so I'm new to this. I'm just curious, when does the District Court Judicial Conference meet, and how often could they change those fees? Thank you, Mr. Chairman.
Senator, go ahead.
Mr. Chairman, with that, I will refer, if I may, to a district court judge who actually attends those meetings.
Your Honor, good morning. Thank you so much for taking time. Senator Furphy's wondering how often your conference meets.
Mr. Chairman, members of the committee, first of all, thank you so much for considering this bill. It's so important to the district court judges, and thank you so much to Senator Nethercott for her willingness to bring this to the committee. We meet 3 times a year. We're required to do that pursuant to our rules to make changes that need to be made and to discuss issues before the district court judges. So we meet fairly regularly during the course of the year.
Any further questions? Senator Cooper.
Thank you, Mr. Chairman. Senator Nethercott, it appears to me like you're trying to insert some common sense into this system. Is that allowed?
Not so much anymore, right, Senator?
We shall see, Mr. Chairman.
We hope there's still some common sense.
I have some scary memories of Senator Schuler's bill for the fingerprinting fee.
So, Senator, to follow up on that, I actually learned quite a bit in visiting with you last night and studying this a little bit. I am surprised that these fees even ended up in law in the first place. It just doesn't seem commonsensical at all. So that's really what this does, takes that out and puts it in the district court purview, right?
It does, Mr. Chairman, really where it is appropriately placed with, again, all of the other requirements for court reporters, and allows just a little more flexibility. Again, for those fees, and I'm not being, realistically, for those fees to go up or down as necessary instead of the need to find a legislator to bring a fee bill forward. And the likelihood of that happening, I think the last time this issue was ever addressed by the legislature has been at least 20 years.
I think probably because they're like me, they wouldn't have any idea what kind of fee to put on what you do, so. Tammy, please offer us any thoughts you have on this bill, and thank you for being here this morning.
Thank you, Chairman Landon. Thank you all members of the committee. We are thrilled to finally be here. It's been a long process. 21 years ago, I actually worked on the committee that came and got a $1 increase at that date. And so it's been a long time. I think the thing that happens the most that I hear is, why so long? And the truth is, we don't have the time. This has been very hard for about 3 of us. And thank God we got Senator Nethercott that listened to us. But to have to come before you, gather all our data, do our nationwide studies, which we've been doing for months, it's very difficult when we have judges amongst us that are very knowledgeable at what we're doing, that can hear us, that can look at the nationwide studies. We can verify those with our national organization. So we really need an easier access point, and this would do it for us. We have all the data. We can tell you what the surrounding states are. Our biggest concern is our recruitment and our retention of court reporters. We have 26 court reporters in the state that are officials that this affects. If we were to get a page rate increase eventually, what we were asking for was about a 60-cent fee. That's what we felt was reasonable considering the current wage rates in the other states. South Dakota is now at $4.25. We're at $3.25. That was the 2021 number, or 2001 number. Nebraska has just recently gone to $3.75. They have a $3,000 sign-on bonus. They also will pay for the writers that are about $5,000 in the software. That's also about $4,000 to $5,000. Colorado is right now, as we're speaking, working to get their set at $4 a page. And we have every reason to believe that's going to happen. Federal rate is at $3.65 now, but it's being adjusted. Idaho at $3.25, Iowa at $3.50. And we don't even anymore look at the outer states that are urban. California is $6.57. We've been recruiting from Texas heavily, trying to get someone to come here because we keep hearing that after the grid issues and everything that they wanted to come to our lifestyle that we can offer here, safety, nice environment, outdoor activities. What we're hearing is, why are you offering wages that we got 30 years ago? Their salaries, the latest emails we're getting are 130 plus. Their page rates are $6.50 currently in Texas. So we did just have one come last week. She traveled here on her own with her husband and is interested in our Green River position. She enjoyed it here, wants to move here. Her husband is thrilled. The problem is selling her home. Once she sells it and moves to Green River, what she's going to be making is considerably less than what she's making now. So she's doing a budget for her family and trying to figure out if she can actually make that happen while her husband is looking for a job in the oil and gas industry. So that's our hope. We currently have 3 openings. I work heavily with our Wyoming Court Reporters Association on working on recruiting and also legislation. I've been reporting for 25 years in the district, Cheyenne, worked through 5 judges, so I kind of feel like I have a feel now for how we hire people, how we find people. There's been trends in the court reporting industry that have been impactful for us to be able to bring people here. When I started in 1990, I was at a school in Denver that was a brick and mortar. It was common then that you went to a school, you walked in, you were there every day, you had the support, you were out in 12 to 24 months, generally on the long end. Some of us were working, so we had to fit it in on night school. It was quick, you had the support, and we had so many court reporters. When I came back to Cheyenne to work, there were 2 huge statewide freelancing firms. They covered all our needs. There were waiting lists to be official reporters. When I applied, I believe there were 22 applicants. And we had a test that was administered, And they graded them and then picked and selected from that. And that was at the time of Judge Kalakathis. I also worked with Judge Meyer in those days. Things are very different here, and they changed again in 2020 when COVID hit. Now we don't have enough court reporters in the United States. We have a shortage. We're working on bills nationwide to provide money so that we can do scholarships to get court reporters. We're doing recruiting. You'll see a lot more on the news. You'll see a lot more media hits trying to recruit. Each one of us does a mentor program. I now just have one. I also have one that has just taken over in Casper. She's graduated on her own doing online and is now an official there, and we're very excited about that. Finding people to take on the online program is difficult. It can be between 3 to 6 years now. It's very expensive. You don't get the support you do in a school. So we have fewer students, thus fewer court reporters in our pool. What's happened is, as recruiters, we volunteer with our association, we work with our human resources at the Supreme Court. We do a lot of social media blitzes. We advertise on everything on Facebook that's related to court reporters that many of us subscribe to. We do a lot of national ads. We contact our national association who helps us. Our national president now lives in Fort Collins. He's been wonderful to help us. We used to call state agencies and say, we have an opening. They'd say, we have 4 people here that are looking for jobs, we'll send them your way. Now we're all in competition. And we're in competition with people, as I've noted, that make more than we can offer them. We want to be reasonable, and we know that the salary is set, it's where it is. But we can at least have a little leeway if we have our page rates up. I can say to the girl in Texas, you're making $650. Maybe we can offer you $385. It's not going to be a lot, but at least we're trying. She writes me every day and says, how's the legislation coming along? We had another girl that came.
I think we've got an opportunity, and honestly, Tammy, really appreciate all that help you're giving us and all the information. I think there's some sentiment that maybe we can leave that to all of you to deal with instead of us trying to figure out what a page rate ought to be. So,
Thank you, Mr. Chairman.
Really appreciate it. I'm going to cut a little short because we've got a couple more bills to consider, and
Great.
really appreciate it. Can you help me with your last name again, Tammy?
Yes, I have 2 names, but first one is Trowbridge, T-R-O-W Bridge. Last name Fleming.
Sorry, I wasn't a little more formal. I missed your last name. It's great to meet you, and thanks for being here. Your Honor, I want to get to you. Any thoughts any additional thoughts you'd like to provide?
I believe Senator Nethercott and Tammy have more than covered it. Senator Landon, again, this is a little bill in terms of, I think, the financial impact it would have on the state, but it's a big bill in terms of the assist that it would give us in recruiting court reporters, which are such an important part of our judiciary and the quality of the service that we provide to the public. So thank you again for being willing to consider this.
Okay, thank you too. Really appreciate it. I want to go to testimony on this bill. Any testimony in the room on Senate File 108? Any testimony from inside the room here? Judy, did we have anyone raising a hand on 108? No remote testimony. Okay. Senator Nethercott, before we close testimony, any wrap-up thoughts on it?
Appreciate your time this morning. Thank you, Mr. Chairman.
Thank you. I'm going to close testimony on 108. Committee, what's your pleasure on this bill? Moved by Senator Furphy. And discussion. Any further discussion? Committee, I think my inclination is to set this aside, and we'll take a vote on this bill as soon as Senator Case gets back. I want to give him the opportunity. I don't think he left a vote on this one. So I want to leave the vote open. Okay, so let's set this aside. Remind me to come back to that, Mr. Vice Chairman. We've got to take a vote on 108 here in a few minutes, and we'll get our partner back. Okay, Senator Schuler.
Thank you, Mr. Chairman. I just, before Senator Nethercott goes, would there be any issue with making this immediate rather than July 1st? Would there be any problems with that?
Mr. Chairman, Senator Schuler, that would be a wonderful amendment.
Well, we might want to just go right back to 108. I sense that there's going to be an amendment offered, Senator Schuler.
I would offer, if you're ready for that.
I'm ready. Hi, Golly.
Thank you, Mr. Chairman. I would offer that amendment that we make the act effective immediately. Page 2, line 8.
Discussion? All in favor of Senator Schuler's motion to make the act effective immediately, please say aye.
Aye.
Any opposed? No. That amendment passes. Judy, did you get that? Okay. All right. And once again, let's set this one aside, and I want to get over to the next bill for our consideration, which is Senate File 112, peer support counseling confidentiality. Once again, Senator Nethercott.
Mr. Chairman, thank you for the time this morning. If I may, I'll go ahead and just invite up Cheyenne Police Department Chief, Mark Francisco. Chief, come on up. Of course, we have Byron Odekoven waiting in the wings here from the Wyoming Association of Sheriff and Chiefs here as well in support of this bill. I know you're busy for time this morning, so wanted to move us along. So, good senators, Senate File 112 is peer support confidentiality. The importance of this bill relates to the need for first responders and primarily police officers, law enforcement officers, to have the ability to communicate and have confidential conversations with each other, really concerning traumatic circumstances or events that they have experienced. As you likely know, no one really knows what it's like to be in the trenches or to have experienced something unless you've done it together. We in the legislature certainly can experience that, and police officers know that just as tenfold what that's like. And so oftentimes it's helpful for them to have the ability to discuss what they have experienced with each other, and those that have been identified with a special designation by this bill of being peer support specialists. And there's a special designation associated with confidentiality. And the reason why that's important is that our law enforcement officers are subject to special regulations as a result of us empowering them to have power of arrest and carry firearms, that they are under stricter scrutiny than the rest of us are in our employment matters. And so they have to pass fitness for duty requirements and psychological fitness for duty requirements, and they can be disciplined for those types of related things or potentially lose their employment. And so there's a lot of hesitation for first responders and law enforcement to discuss issues they may be experiencing. And this bill provides some protections statutorily to encourage those conversations to occur within a format that is has some safeguards associated with who may they speak with, so to encourage that type of conversation so that they are fit and healthy and ready to serve the people of Wyoming. So with that, Mr. Chairman, I'm happy to stand for questions. If not, I'll turn it over to the good chief.
Senator Nethercott, we're going to grab a water. You've been working all the way through 3 bills already. We're going to get you a water. Thank you for those comments. Any questions, committee, on what the bill does? Do you want to walk us through real quickly, just at a 30,000-foot view maybe, and then we can get on to testimony from these 2 gentlemen. Appreciate you guys being here, and we'll get to you in just a minute.
Absolutely, Mr. Chairman. This is not a new concept in law, so other states have passed similar types of legislation, and this particular bill draft has some history out of the state of Missouri, just so that you know. So we're not creating anything new. The first, starting on page 2, of course, is definitions. So who does this bill apply to? And as you can see, it applies to emergency services personnel. There's a definition for emergency services provider. And here on Romanet 3, line 13 on page 2, is an employee assistance program. And that means a program established by a law enforcement agency or emergency services provider to provide professional counseling or support services to employees or volunteers of a law enforcement agency or a professional mental health provider association with a peer support team. And so this is kind of what this bill is contemplating, is an agency having an employee assistance program, and how that program then interfaces with the employees who work within that agency. obviously the definition of a law enforcement agency. Working through, we have law enforcement officer, no need to describe that. But on page 3, line 11, we have a peer support counseling session. It means any session conducted by a peer support specialist that is called or requested in response to a critical incident or traumatic event involving the personnel of the law enforcement agency or emergency services provider. The next, going on to line 17, this is important. Who is a peer support specialist? Can anyone be one of these? And the answer is no. Here's what those requirements are. Has to be designated by a law enforcement agency, an employee assistance program, or a peer support team leader to lead, moderate, or assist in a peer support counseling session, or is a member of a peer support team, going on to page 4. Really important here on line 4, page 4, has received training in counseling and providing emotional and moral support to law enforcement officers who have been involved in emotionally traumatic incidents by reason of their employment. So then going down on the bottom of page 4 is what is this peer support counseling session that's contemplated by this bill draft. That's found on line 17. It's any communication made by a participant or peer support specialist in a peer support counseling session, whether oral or written information is conveyed. And it shall be confidential. So that's really where the emphasis on this language can be found, is on line 20, at the end of that line where it says shall be confidential and shall not be disclosed by any person participating in or conducting the peer support counseling session.
So, Senator, just a quick interlude here. That sure makes sense to me, that language. And I'm assuming that means that this doesn't go on any employee record as such. Is that part of what this is alluding to? Am I in the right neighborhood there?
Mr. Chairman, that is my interpretation, that this shall be confidential to encourage those conversations to occur. Moving down on page 5, you can see also very clear that it's not to be a public record. As we know, law enforcement officers, law enforcement agencies, much of their activity or reports or video footage is subject sometimes to Public Records Act requests. And it is very important that these particular conversations are never subject to those laws. Sunshine is good, but not all the time. Also moving on to page 6. Here's where we go to address your concern, Mr. Chairman, where it says on line 18, nothing in this section limits the discovery or introduction into evidence of knowledge acquired by any law enforcement officer or emergency services personnel from observations made during the course of employment or material information acquired during the course of employment that is otherwise subject to discovery or introduction into evidence. And so in the event that the information may be necessary in some type of legal proceeding, that information isn't somehow protected as a result of the need for that to be utilized in a legal proceeding. This section shall not apply to threats of suicide or criminal acts, really to make sure that any kind of privileged protection or confidential communications aren't done that need to actually be reported or prevented. So really some sidebars there associated with the breadth and scope of confidentiality. There are some exceptions to this also. You can see on page 6, line 17. If the participant consents to the disclosure, then that's okay, of course. And that, Mr. Chairman, is the bill.
Okay, questions? Senator Schuler.
Thank you, Mr. Chairman. Yeah, I just a couple questions, and I'm sure the chief or any of you can answer this, but this specialist has to be designated by the law enforcement agency, I assume probably the chief or his designate. Could it be someone like a clergy that might be attached already to your department, or does it need to be someone who has a background in law enforcement? Or I guess I'm just kind of wondering what the background is, or would it be just a professional counselor?
Chief Francisco or Mr. Oberkoven,
Mr. Chairman, thank
Chief,
you for
thanks for being here. Appreciate it.
My pleasure. Thank you for taking the time. My name is Mark Francisco. I'm the Chief of Police here in the Cheyenne Police Department. I've been in this business for 32 years, and the peer support legislation is near and dear to my heart. I've over this time seen some tragic consequences, some just resulting in loss of employment, and some far worse. And in my 2 years here in Wyoming, I've seen also a little bit of this. So I think it is important to bring this legislation here to Wyoming. And in answering the question that was posed, peer support is generally, as it states, peer support. So it's designed for law enforcement, other first responders to be able to talk to somebody that is a peer and has received training in peer support counseling. So it is more designed for that. I would say, though, that the clergy conversation already exists, already has a degree of confidentiality. So what this is designed to do is both protect officers that participate in this in state court and also protect them in the course of their employment, so that they are confident to share information with peers without worrying that someone such as myself may go to that person and ask, what was that conversation about? It protects them from job actions such as that. Which is really important in this line of work. Officers probably fear that more than state court testimony. Peer support has been around for decades in a lot of places and has worked very well. It's no longer considered an experimental thing. It is considered best practice now. The missing piece has always been this confidentiality, and as the senator discussed, it has been enacted in a number of states, and I appreciate her support in trying to get it enacted here. And hopefully that answers your question, Senator.
Chief, thank you. Appreciate it. Senator Furphy.
Thank you, Mr. Chairman. I assume a lot of these individuals aren't necessarily from the counseling criteria. So what kind of training do they have to deal with a peer? Thank you, Mr. Chairman.
Gentlemen, either one of you, but Chief, you've been in the trenches.
Yes, sir. Thank you, Mr. Chairman. They're generally trained by counselors, by licensed counselors. Here in Cheyenne, we work with Dr. Shana Smith, who is a vital part of our peer support program. So these folks, these peer support specialists, are not designed to be counselors, and we don't ascribe that they are. They're an ear to talk to, a shoulder to cry on if need be. It's a way to get our individuals discussing their fears, discussing their issues with somebody that they feel comfortable with. Our peer support specialists are trained to recognize what services are available and guide those individuals to those services if they're appropriate. So it's that bridge between formal counseling and just a sympathetic ear that's been through similar experiences that you have and can maybe help you to take that next step.
Chief, thank you. I do want to give an opportunity to Mr. Odekoven, who has also been in the trenches and now represents all of our folks out across. Mr. Odekoven, thanks for being here. Any thoughts on this bill? I want to get to you on that.
Thank you, Mr. Chairman. Byron Odekoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. This represents the formalization of what we would like to do and enfolds that confidentiality piece in, which is very necessary. Yeah. We've dealt with critical incidents and critical incident management, crisis teamwork, if you will, within, but it always skirts the edge a little bit on whether the officers will visit, talk, and fully disclose. because they're worried about that level of confidentiality. The Missouri model that we patterned this discussion off that the chief brought to the association, sheriffs and chiefs looked at it and said, this is good. We would like to be able to do this. So working with Senator Nethercott to put it into Wyoming bill form, if you will, which is always that tricky moment when you bring an idea to, has been very rewarding, working with sheriffs and chiefs, looking at the issue and how best to proceed. Mr. Chairman.
Mr. Odekoven, thank you. And I always am proud of what our statutes look like. I think we do a good job on that front, and sometimes we have to clean things up when they come here. Committee, any questions for Mr. Odekoven? Okay, thank you very much.
Mr. Chairman, and when we
further
get
thoughts,
when we get just finished with questions, in working with the rest of the constituents, if you will, or parties to this, I have a couple of wordsmithing issues to clarify the point of counseling versus peer support. As an example, that we in working the bill here, once we need to make a couple of one-word changes in a few spots. Mr. Chairman,
can you take us through them right now?
I'm ready to do that. I just wanted to finish questions before we got there, Mr. Chairman.
Perfect. I think we're past the question stage, and please continue.
Mr. Chairman, and I think
locate those suggestions for us.
They were working on multiple bills this morning, and I said I would carry the message if folks weren't here. So let me carry the message on the one-word changes. So beginning on the top of the page where it says peer support counseling confidentially as the title of the bill, they would like to take the word counseling out and put services in. And that's the theme through the rest of the changes, if you will. So at the top of the page, the title of the bill, take counseling out, insert services.
We will take that under advisement, but Mr. Odekoven, I'm not sure
I just got the word on that.
That is something we
Chairman?
don't do. Yeah.
And then in that case, Mr. Chairman, jumping to line 12, we would ask the same thing.
Mr. Chairman, if I may.
Senator Nethercott.
I think that the counselors are concerned about calling it counseling, and they, that's invading into their occupational space. As you know, we can't change the title of the bill. However, throughout, I think starting on page 3, line 11, if they want to call it a peer support services session, I think their concern is using the term counseling. Another alternative is a definition associated with counseling as applied to this bill and this section, which is probably more prudent than trying to change the terminology throughout, which would be counseling shall not include professional services provided by those licensed under the state mental health licensing boards to provide counseling services. I can work on an amendment for first reading.
Senator, thank you. I'm inclined to think that's a great way to approach this rather than trying to work it through this morning here. We can certainly do it here too if you feel like we can do it on the fly, but we'll get to that in just a minute.
Mr. Chairman, you certainly can. I don't have the correct statutory references for that, so.
Senator Case, welcome back. I'm sure you can weigh in. You're one of our parliamentarian kind of senators. Yeah, we do not touch the title of bills.
Mr. Chairman?
Go ahead.
We don't, except for when we do. Sometimes you will see amendments brought that amend the title. The spirit is not to be deceptive and not to, the Constitution talks about the title must indicate what the bill is about. And so we've come to appreciate the chance to make minor changes a little bit and tweak the title in that area. As you know, we had a big debate on that in the Senate floor when it probably got a little far afield. So we could look at it.
Thank you for that. it's quite rare that we go into that neighborhood, and I'm more inclined to go the direction, Senator Nethercott, that you suggested. I think we can catch this on committee of the whole or even second reading, and we can disclose that up on the floor. Look, we've got some language change we're working on or whatever. I think that might be the best approach. Thanks for bringing that, Mr. Odekoven. Anything else?
Mr. Chairman, thank you. I thought thank you for the clarity.
Appreciate that. Thank you too for being here. We will work on that, okay? Committee, anything else for these three? Any questions? Okay, let's go to any other testimony. Do we have any testimony, Judy, from out there in Zoom land? Okay, thank you. I'm going to, you're very welcome to come and you're very welcome to come testify. My apologies. It didn't look like you indicated you were going to, so welcome.
Well, the seats were so full. We were excited to have them be here. Mr. Chairman, members of the committee, my name is Lindsay Simoneau. I represent the Wyoming Counseling Association. We very much support this bill. As the chief of police so kindly said earlier, these have gone to evidence-based and best practices and would like to see their confidentiality ensured. As previously spoken to, the issue does come with the word counseling because within our Practice Act under Wyoming Statute 33, 38, 101, counseling is given a very specific definition for master's level clinicians only. And with the hopes of avoiding confusion or a trade war later, we think that the easiest way to do that is to, for the most part, omit counseling out of the bill. We recognize that once a bill is titled, that is pretty much finalized. We're not too worried about the title of the bill as much as what is put in statute. And so as much as possible, being able to remove counseling and whether that is peer support session, peer support service, we will leave that to the pleasure of the legislature. However is the easiest and cleanest way to do that, we would appreciate. And yeah, we're not looking to die on any hills today. So, and with that, I stand for any questions.
No, Ms. Seminole, thank you. You bring up a good point. I think we can work on a fix. So thank you very much. Any questions, committee? Thank you, Lindsay, appreciate it.
Wonderful, thank you, Mr. Chairman.
Okay, we're going to close public testimony on the bill. Any final thoughts, Senator Nethercott?
No, Mr. Chairman, thank you for the time.
Okay. Committee, what's your pleasure on this bill?
Move the bill.
Okay, moved by Senator Schuler. Discussion. Any discussion? The only discussion piece is just, we'll be glad to back you up there, Senator, with an amendment coming. Okay. Judy, would you please take roll on Senate File 112, and then we will return to Senate File 108 for a vote. But Senate File 112, please take roll.
Aye.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there are 5 ayes for Senate File 112.
Okay, Senate File 112 has passed the committee. Okay, thank you very much. Senator, nice work this morning. Thank you, Chief, for being here. Mr. Odekoven, appreciate your input. Committee, Senate File 108. I held this vote open so that Senator Case could get back. I think he's very much aware of the bill. So Judy, would you please take roll on Senate File 108?
Senator Case.
Aye.
Senator Cooper.
Aye.
Senator Furphy.
Aye.
Senator Schuler.
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there are 5 ayes on Senate File 108.
Okay, so Senate File 108 has passed the committee, and we'll go upstairs to the Senate chamber. We have one bill remaining, committee, and I was hoping at least to get testimony on that bill completed, but if Senator Dockstader can get here, Senator Nethercott went to get him. I think we have time to take a look at that bill that's resting comfortably right now in front of us. Senate File 116, Protection of Lawful Commerce in Firearms. Okay, so let's take a 5-minute break and stay put, waiting for Senator Dockstader. How about that?
You are the Senate. You have curse.
There you go.
What time do we gavel in, 10 or 9?
10 o'clock.
10 o'clock.
Yeah. Yeah. I was thinking that he might go 9:30 again, so I started 7:30. But the good news is, committee, we're working through these bills and getting them up there, so that's good.
Oh, yeah, we did.
Well, for those listening in, we are back in order. We took a little recess to wait for one of our colleagues who will bring us Senate File 116, Protection of Lawful Commerce in Firearms. And so we're back underway, committee. Welcome, Senator Dockstader. Thanks for being here, and please
Mr.
walk us
Chairman.
through your bill.
Thank you, appreciate that. Mr. Chairman, members of the committee, bring you Protection of Lawful Commerce in Firearms, Senate File 116. And folks, I was watching the scenario where we seem to have repetitive lawsuits against those who have manufactured the product, when in fact they're just part of our commerce across the US. And in full disclosure, I have a manufacturer in my area, but they did not ask me to do this. This is just something I was observing and watching and seeing if there was perhaps a better angle we could take from the state level while there's a federal level. I'd like to take a look at it from the state level. So in the opening title, Specified Immunity of Firearm Manufacturers, that's where we lay the groundwork. Then we start into the definitions on page 2. Ammunition, firearm, firearms accessories, manufacture, all of those defined. And then we move into what civil immunity is and is not in line 16. It shall not include the following. And we go into more definitions: qualified product, seller, trade association, unlawful misuse. And then we note that the sellers of qualified products and trade associations shall be immune from civil liability in a qualified civil liability action. And then to clarify and to make sure that we weren't protecting those who essentially did not deserve the protection, we make sure that the immunity does not include convicted felons. That's lines 4 all the way down to the bottom of the page, those who are not immune. And then we define knowingly, which I know over the years has been one of our favorite terms to debate, but knowingly that they're not protected. Again, as we go through the rest of the bill, we emphasize that the immunity is not for felons, convicted felons. That's who we're not trying to protect here. What we're trying to do is protect those who manufacture the product. And it's my understanding we've got more that are doing that in Wyoming, and possibly even more in the future because the political environment out there, they look for states that tend to lean into these rights more than others. So, Mr. Chairman, members of the committee, that's protection of lawful commerce and firearms.
Senator, thanks. Appreciate you being here with that one. So, committee, any questions for Senator Dockstader? I actually had one as I read the bill, Senator. I sure like the concept. I wonder, do we have any concerns about the manufacture of a defective product? Where does that come in? Where did I miss that? In other words, let's hypothetically say we have a situation like they had down in New Mexico, and a firearm misfires or has a trigger defect, a firing pin defect. We certainly aren't giving immunity on fronts like that, are we?
Mr. Chairman, it's not intended to, and I believe we had language, but it's not intended to cover a product that's defective. And if we need to more.
I probably just missed that, Senator.
We need to specify that.
Oh, thank you. Okay.
Page 5, line 20.
Okay, gotcha. There it is. Okay, we're covered. We're covered. Thanks, Senator, for indulgence. Committee, any other questions? Senator Schuler.
Thank you, Mr. Chairman. When I was reading through the bill, I just, and I didn't do my own research, I should have, but I was tired. So I just wondered if any other states have done anything quite like this bill.
Excuse me, Mr. Chairman, if it understates, what?
Are any other states had any interest
I
in?
understand.
Yeah.
Mr. Chairman, not that I'm aware of. I understand we have some federal, Senator Schuler, we have some federal legislation that addresses it. I wanted to make it more specific to Wyoming.
Thank you.
Okay, thanks for that, Senator. Senator Cooper, you have something? No. Good. Any other questions? Okay. Mr. Odakoven, you are a busy guy this morning, but do you have any interest in testifying on Senate File 116? That's what we are taking up now.
Lawful commerce firearms.
Lawful commerce in firearms, providing some protection for our manufacturers a little bit. Are we good?
We are good.
Okay, good deal. Well, we wanted to come to you because you're the only one who stayed with us, or came back with us. I appreciate it. Senator Dockstader, any other further thoughts to finish up our discussion?
No,
I'm sensing that we're about ready to vote on
Mr.
it.
Chairman, just trying to take care of the commerce that appears to may be growing in Wyoming.
Okay, thank you very much. Just double checking, Judy, anybody online that wants to testify on this bill? Okay, I'm going to close public testimony on Senate File 116. What's your pleasure, committee?
Move the bill.
Cooper moved it. Discussion.
Mr. Chairman.
Senator Cooper.
I thought this was going to be kind of a confusing and controversial bill, but when you read it, it's not. It's pretty straight up. And it's built to protect our manufacturers from some of these frivolous lawsuits that are out there, and I think it does a very good job at that. So,
thank you, Senator. Appreciate it. Are you ready for the question on the bill? Okay, Judy, please take roll on Senate File 116, protection of lawful commerce in firearms.
Senator Case.
Aye.
Senator Cooper.
Aye.
Senator Furphy.
Aye.
Senator Schuler.
Aye.
Chairman Landon.
Aye.
Mr. Chairman, there are 5 ayes on Senate File 116.
Senator Dockstader, we're right behind you when the fight breaks out up top, and look forward to it. Thank you for getting down here to join us.
we'll be pretty far behind if this shot's fired.
Committee, that's basically it. We have one bill left in the hopper. That is a Barlow bill that he's working on a little bit. So we pushed that off to next week. We'll probably take that up Wednesday morning. I don't see any reason for us to have a special meeting Tuesday afternoon. Senator Case.
Mr. Chairman, we're pretty loaded up in the Corporations Committee. I'm wondering if the committee might consider, I'm trying to find a home for 2 bills. One of them is Senator Furphy's bill with respect to hearing aid coverage. And it'd be a big lift if we could help. There's another one, it's also a coverage bill, and it has to do with dentistry. Those might be good to go together. If we're light, honestly, we're going to be full in corporations with early starts probably Tuesday and Thursday. And our problem is we're a Tuesday, Thursday committee. And so we start with 2/3 the horsepower that this committee has. Is there any chance that the committee would
Senator,
consider?
absolutely. You know what? I think we just move to send those 2 bills over. That'll give us 3 to consider on Wednesday morning.
That'd be great.
And that'll take a little bit of pressure off the Corporations Committee.
And Senator Furphy, would that be okay?
Yeah, I want to make it clear on this hearing aid bill, there is a big group of deaf and hearing impaired that want to come and testify on that.
Okay.
So I just want to make you aware of that.
I'll let you know right now. We'll put that bill up. Judy, make a note of that we have a corporations bill coming on hearing aid coverage, Senator Furphy's bill, and we'll put that up Wednesday morning.
You say something?
Okay. Wednesday morning.
I'm looking at all the hearing aids down this row.
I was gonna
knowing
say,
that
am I the
need
only
one.
one that doesn't have a hearing aid? However, I have one ear that I can't hear out of, so.
The good news is on Saturday, Sunday, and Monday, while we're gone, the group that we have hired is coming in to work on the acoustics of the Capitol building. All of this. When it was remodeled, it really changed things in there, made it hard to hear. Oh, anyway, yeah, Senator up top, if you want to make that motion at some point,
That'd be great. I think I'll do both those bills.
Yeah, that sounds fine. We can take them.
Chairman
Committee,
Landon, do you have those bill numbers?
I'll get them to you, Judy.
Okay.
It's the dental coverage bill and the hearing aid bill. Okay? So, committee, we are adjourned.
Is that dental coverage bill, the bill that I had?
I believe it was.
I think I'm gonna drop that. I think I'm gonna withdraw that bill.
Okay.
It's got some issues that I think that are not fixable.
The dental one?
If you want to send it to me.
We'll handle it.
I've got a big drawer, or you can hold it.
Can I do that?
You get
It's got